Hi, my name is Carrie Jacobson with Jacobson Family Law, and today I want to talk about whether or not your loved one can designate you as their power of attorney if they have dementia. So, this is something that often comes up when people are newly diagnosed, and many times they need to have their loved one, you, take care of their financial affairs and other things on their behalf. So, I want to talk about the timing of when it is appropriate to have this done. So you can only have your loved one give a power of attorney if they are legally competent. And so what this means is they need to be able to have legal capacity to be able to understand the document that they are signing and its natural consequences. So this is a scenario where you don't want to wait until your loved one is in the throes of dementia. If they are recently diagnosed or even before a diagnosis would be the ideal timing for having a power of attorney signed. If your loved one cannot understand the legal consequences of the power of attorney, then it's a scenario where you're probably going to have to file a petition for court with the court to be appointed as their guardian. Now, this is something that does take longer, and generally does require court oversight. So, if there's any question as to whether or not your loved one does have capacity, one of the things that you can do is have their doctor sign a paper, get explicitly stating whether or not they believe your loved one has mental capacity in order to sign a power of attorney. And this will assist in making sure that the power of attorney that is signed can't be challenged by your other family members or potentially third parties. One of the best pieces of advice is get a power of attorney early on, before a diagnosis or shortly thereafter, so that there's not a question as to whether or not your loved one has capacity. If you have any questions about getting a power of attorney for yourself or your loved one, contact us at the link below today.